Please read out the portion.
Yes, ma'am. Malad, this judgment of 2021, Malad, this presided by the Malad Honorable Chief Justice of India and other two judges, Malad, where this entire scenario and perspective has been described with regards to the Fajan Lal, Malad. Then this finding has come, the paragraph 16, Malad, and 17 and 18. An interim order of stay of investigation during the pendency of the quashment petition can be passed with circumspection. Such an interim order should not require to be passed routinely, casually, or mechanically. Normally, when the investigation is in progress and the facts are hazy and the entire evidence material is not before the High Court, the High Court should restrain itself from passing the interim order of not to arrest, no coercive steps to be adopted, and the accused should be relegated to apply for anticipatory bail under Section 438 CRPC before the competent court. The High Court shall not, and as such is not justified in passing the order of not to arrest and no coercive steps, either during the investigation or till the investigation is completed and or till the final report charge sheet is filed under Section 173 CRPC, while disposing the quashment petition under Section 482 and or under Article 226 of the Constitution of India. In paragraph 17, I am skipping. Paragraph 18 said, whenever an interim order is passed by the High Court of no coercive steps to be adopted within the aforesaid parameters, the High Court must clarify what does it mean by no coercive steps to be adopted, as the term no courses to be adopted can be said to be too vague and are broad, which can be misunderstood and or misapplied. So far as the legality of the impugned interim order passed by the High Court in the present case directing the investigating agency, police, not to adopt any coercive step against the accused is concerned, for the reasons stated herein below, the same is unsustainable. Milord, this has been said, why such unsustainability of this order, Milord? So, Milord, when the investigation is in a very nascent stage, evidence to be collected, Milord, then the investigation, because, Milord, then in the judicial proceeding by 226, Milord, if there is no such, Milord, only an imaginary figure that there is an attempted by a malafide or the abuse of power, this should not be interfered, Milord. The independent agency, Milord, we are investigating the matter, Milord, and then, Milord, it will come to the logical conclusion.
The basic issue is, what is the criminality? In absence of any criminality, how can you proceed?
Milord, if you lordship see the section 353 subclause 1 subclause B and 353 subclause 2, Milord, it is the criminality. And each and every word statement which has been published, Milord, this is the criminal acts, Milord. And also 267 is someone to be affected. That would be, I will not raise this with regards to that. But when there is a one cognizable offenses, definitely police has registered and the investigation is in progress. This is the criminality with regards to the when it has disclosed by when criminal complaint, Milord.
My lord, since Mr. Bhattacharya is here, with his permission, I want to only cite one judgment. This was argued by Mr. Bhattacharya before the division bench of this honorable court, when Honorable Chief Minister of the state, while standing in West Bengal Legislative Assembly, said the judgments could be purchased. And there, the division bench of our court, comprising of the Honorable Chief Justice Jain Patel, then his lordship was, and Justice Bakshi, the beautiful paragraph.
That was Justice Mishra and Justice Bakshi.
And it was a beautiful paragraph. May I read it? Paragraph 27. We are therefore not persuaded by the submissions of Mr. Bhattacharya that the imputation of the context of the entire speech can be said to be one which transcended the Lakshman Rekha of scandalizing the court or obstructing the administration of justice or interfering in the due course of judicial proceeding. We are therefore unwilling to so much to invoke our power to initiate for the contempt in respect of the aforesaid imputation. We make it clear that our reluctance to initiate such proceeding should not be taken as an approval of the statement made by the speaker. One must not lose the sight of the fact the speaker was not an ordinary personality but the Chief Minister of the state. It is expected that when criticism is made from such high constitutional functionary, the same should be laced with moderation and temperance. The imputations were neither moderate nor couched with temperate language, although the same in contextual matter, according to us, may not constitute. So, Lordship, judiciary in our country stands in a high pedestal. This cannot be did in such a fashion by anybody and everybody. And that is the consistent stand which Supreme Court has followed everywhere, Lordship. So kindly wash it, Lordship.
No, but I would again repeat, Lord, that if the FIR complaint does not disclose any cognizable offense, it does not disclose any cognizable offense. Criticism, interpretation, that might be wrong, right? That's a different issue, but that is not a cognizable offense. Police has no business to start to register an FIR and start investigation. This is absolutely harassing. Can you see the complaint, Lord? And who is state of PP? Well, himself, Lord, is failed to give his own identity. There is nothing called PP for state of West Bengal. A person who misrepresents himself. If I may use that expression, very sorry to say, he's a lawyer. PP of state. Who has appointed as the state PP? And was he authorized by the state to lodge this complaint? He could have done it in his own personal capacity, but not in the capacity of the PP. Help karo.
Well, with regards to that, Mr. Chaki's complaint, I can submit, my lord. Let it be, my lord.
Quashed.
Let it be, but this complaint, my lord, it has some substance, my lord.
Chaki's complaint quashed.
My lord, it
On
has,
consent.
Nothing,
my lord,
nothing remains.
My lord, consent means because if you lordship see the ingredient,
Yes.
see the ingredients.
So you give consent.
My lord,
I'll record your consent.
my lord, I am interested. My lord, consent to some extent is my submission before your lordship. Candidly, it cannot be constituted as a consent. I said that
It ought not to be proceeded with.
maybe because
The manner in which the complaint has been
But
lodged.
this complaint of Otri Sharma, in each and every word which he has transcribed from the video footage or the published, that constitutes 357 353. So that requires to be to some extent investigation. And
So Mr. Chaki's complaint,
If the Chaki's complaint goes,
yes.
then automatically other complaint goes.
There is a
These are
separate
fundamentally-
independent complaint by Otri Sharma.
But the content of all the complaints are same.
Otri Sharma is a bit detailed.
Might be, but detail
Chaki's
doesn't.
complaint is as vague as anything.
Yes.
But Otri Sharma has something which the state intends to proceed with. Now, what will happen, I will decide it. That is something different.
Lordship, you monitor.
First of all, the PP is
without the
lodging
leave
a
of the court,
complaint.
he will not do anything.
May I speak?
Yes,
But
please.
that complaint does not disclose any cognizable offense by an YouTuber. He has a better fundamental right to disseminate information. If any wrong information goes, that cannot be said to be criminal offense. The information, whether that incites the people to work against the state integrity, if that is so, then there will be complaint, otherwise not.
That information is a distorting and the false, my lord. If your lordship, I will
Being false,
invite
false
lordship,
is
which we have kindly
false is
examined
not
our
criminal
CD.
complaint.
It has been seized, my lord. Kindly see at any point of time, your lordship will see in every word, every sentence.
Very well, I'll pass order. See, it's 1 o'clock. I am at serial number 16, 17 only. So much time these matters
But
consume.
in the other days, my lord, it was just a, from today, by 1 o'clock, you have lordship.
Half the list is
60,
exhausted.
60, 70
Yes.
matters. Today we are late. One day we take a
I'll pass order in my chamber.
Lordship.
Finish. Let me see
Lord.
what happens.
May I hand over this?
Please.
Give interim orders.
Sorry for
let me
this
see
taking
once.
trouble, my lord, which is
Let me see once.
also, my lord, troubling to me.
Which are the paragraphs that you referred?
My lord, 16, 17, 18. And also, my lord, I maybe excuse this, I have marked my junior.
Doesn't matter.
Grateful.
I'll check up. I'll pass out orders in my chamber today itself. Call the next matter.
Biplab.